Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director and Vice President for Legal Studies for the Foundation. For those of you not familiar with the Foundation, we are in our 47th year of free enterprise education and advocacy on a wide range of legal and regulatory issues. We do most of our work in the courts and the administrative agencies, where just about everything is decided these days. This is one of the programs that we do that educate our viewers on a pretty wide range of issues that affect the free enterprise system. This is one that definitely has really wide-ranging applications, so we hope you enjoy what you're going to hear today. As two of our panelists, along with one partner of theirs, back in January 11th, 2023, wrote for WLF in the Legal Backgrounder, quote, "For over 200 years, the regulation of non-competition agreements has been entirely the province of state law. No longer, as the Federal Trade Commission leaned quite superficially on its authority to regulate competition and label business activities unfair in its issuance of a final rule that requires amendment of most employment contracts that contain non-competition clauses. It does so not only prospectively, but applies retroactively to most existing contracts. 3 of FTC's 5 commissioners remarked that the commission did this to advance, quote, economic liberty. As promised, as far back as FTC's release of the notice of proposed rulemaking, affected entities, including the Chamber of Commerce of the U.S., have filed suit in federal court to enjoin the rule. We're pleased to be joined today by 2 attorneys who have followed the rule's path to release carefully and know have quite a bit to say about the requirements and the legal future of this rule. Stuart Gerson is a partner in the Washington, D.C. office of Epstein, Becker, Green. He has enjoyed a distinguished legal career in both private and public service. He was appointed acting Attorney General of the United States during the early Clinton administration after having served President George H.W. Bush's appointee as the Justice Department's Assistant Attorney General for the Civil Division. We're also proud to say that he's a member of WLF's Legal Policy Advisory Board. Joining him is Erik Weibust, who is also a partner with Epstein Becker, practicing in the firm's Boston office. He is a co-chair of the firm's Trade Secret and Employee Mobility Practice Group and edits its Trade Secret and Employee Mobility blog. Before joining the firm, he practiced at another international law firm and clerked for the Honorable Peter W. Hall of the U.S. Court of Appeals for the Second Circuit. I remind you that this program is being recorded. If you have any questions, please use the Q&A function located in the Zoom webinar toolbar, and we'll be displaying a PowerPoint slide deck, which we've also made available in the chat function that you can download as a PDF. So let me share my screen, and then we'll get started. All right, try to get the correct one. Gentlemen, take it away.
Thanks, Glenn. Appreciate it. And thanks to the Washington Legal Foundation for having us today. We're going to talk today, as Glenn mentioned, about the FTC's non-compete rule. We're going to start with an overview of the rule, what's changed from the proposed rule, and what's going to go into effect, when it's going to go into effect if it's not enjoined. We're then going to talk about all the legal challenges that have been filed and the legal arguments that are being raised. And then we'll very briefly at the end talk about what employers can do in response to the rule. This is going to be far more focused on the legal issues than the practical issues. If you want to learn more about the practical issues, we'd be happy to speak offline, and we've done some other presentations more focused on that. So Glenn, if you could advance probably 2 slides. Thank you. So as folks know, the FTC voted on April 23rd of this year 3-2 on party lines to issue a final non-compete rule. And if it's not enjoined, which we expect it will be, as Stuart's going to talk about primarily, the rule will go into effect 120 days following formal publication in the Federal Register. That happened on May 7th, meaning that the final rule will go into effect on September 4th, if not enjoined. So what would the ban do? What would the rule do? It would ban virtually all post-employment non-competes nationwide. And in fact, it would ban all non-competes, post-employment non-competes, following the effective date of the rule. The only exception is existing non-competes with senior executives. What does that mean? Senior executives are defined as people who make over $151,000 a year and have final policy authority for the entire company, not for a division, not for a subsidiary, not for an office, the entire company. So it's an extremely narrow exception, especially because, again, it only applies to agreements with those folks that are entered into prior to the effective date, so prior to September 4th. Any agreements entered into after September 4th or whenever the effective date becomes will be unenforceable no matter whether you're a senior executive, a junior employee, or anything in between. The commissioner, the chair Khan doesn't even fully understand what this senior executive exception means. She was interviewed just last week on CNBC, was asked by one of the TV personalities, I forget which one it was, said something along the lines of, well, if CBS is right down the street, NBC is across the street. If I go over there, am I not going to be allowed to go over there? Am I going to be allowed to have a non-compete? She effectively said that you'd be a senior executive to this TV personality because you're making a lot of money and you've had an opportunity as a senior person to negotiate, and there's less bargaining power issues. Well, under her rule that she put into place, that's absolutely wrong. It's a very narrow exception. A TV personality would not have authority over the company's policy-making decisions. They just speak on television. So even Chair Khan doesn't fully understand this rule, as far as we can tell. So if the ban goes into effect, what would be required of employers? Well, the first thing is that you'd have to provide written notice to all affected employees on or after the effective date. Previously, there was, I think it was 120 or 180 day time period between the effective date and the compliance date. That was in the proposed rule. And the final rule, it all has to happen as of the effective date. The notice is very similar to anybody who followed California's amendments to its non-compete ban earlier this year, requiring employers who use improper or illegal non-competes or non-solicitation agreements there to provide written notice to employees. It's a little less onerous than the federal one would be, in the sense that it doesn't have to be particularized to each individual employee. It could be more of a blanket notice to all employees. And it doesn't have to be delivered by hand and email. It can be delivered by hand, by email, or even by text message. And there's actually an exception for employers who don't happen to have that information for a former employee, for example. And the notice would have to go both to existing employees and to any former employees who are still within their restricted period under a non-compete. Now, these are changes from the proposed rule, or at least the senior executive exception is, but it's not really a concession. Really, if you read the supplemental information, it's 570 pages that came with the rule. You'll see that what they're really trying to do here is to avoid arguments about retroactivity and that this is a takings under the Fifth Amendment. Essentially, what they're saying is, no, this only applies going forward. Any agreements you've had in the past, you got your benefit of those. You don't have to rescind those. You just have to give notice that going forward, they'll no longer be enforceable, and therefore it's not retroactive and it's not a taking. Kind of a distinction without a difference, in my view.
It certainly has a rearview mirror attached to it. Many commentators have noted this. It's anticipated. I'll talk a little bit about what is likely to become a flood of patent and trade secret litigation, but this is another area, retroactivity, where the FTC's view, or at least the FTC majority's view of this, both defies observable logic and the understanding of the people most likely to be affected by it.
That's right. Thanks, Stuart. So what would the ban? So we know what the ban would cover. What does it not cover? The only real change, in my view, that was material that the commission made from the proposed rule to the final rule is that they added a sale of a business exception. Now, there was one in the proposed rule, but it was limited to folks who owned at least 25% of the business's equity, which Once you start getting venture capital or private equity involved, or even go beyond a small family business, you're typically not going to, most people aren't going to have 25% ownership in any given business. So that was extremely narrow. In my experience with our clients, that's the thing they were most concerned about, even more so than the not having employees and senior employees subject to non-competes. It was the effect it would have on deal making. So the FTC did lower that so that it's any sale of a business, provided it's a bona fide sale of a business, which they define, and essentially say you can't use the sale of a business exception to impose non-competes in creative ways on employees. It's got to be an actual arm's length transaction. But this was the one kind of concession, I'd call it, that they made, and frankly, it's a welcome one. What else is not covered? Causes of action accrued prior to the effective date. So this doesn't mean that you have to have filed a lawsuit by the effective date. It just means there has to have been a breach by the effective date, and you can file the lawsuit after. Meaning that if an employee breaches either the day before or a month before, and you don't find out till after the effective date, you can still file that lawsuit. But if the employee breaches the day after the effective date, you could not file a lawsuit to enforce their non-compete. Not expressly covered in the rule would be other types of post-employment restrictive covenants, customer and employee non-solicitation agreements, confidentiality or non-disclosure agreements, training cost repayment requirements, and the like. But there is in the original rule, there was this concept of a de facto non-compete that got a lot of coverage at the time. And effectively what they said is any of these other types of restrictive covenants may fall within the rule if they are de facto non-competes, meaning if they function to act as a non-compete and prohibit an employee from working. So an overbroad non-disclosure agreement was an example they gave, or a training repayment requirement that was not reasonably tied to the cost of the training. Here they got rid of the de facto non-compete concept, but again, it's a distinction without a difference. It was really just a nomenclature change because they changed the definition of what a non-compete includes as to an agreement that prohibits an employee, penalizes an employee, or functions to prohibit or penalize an employee for engaging in competing activity. So again, just like a de facto non-compete may cover one of these other restrictive covenants, so too could the definition of non-compete under the final rule. And again, that's going to be at the whim of the FTC now or in the future. It's very vague, so we'll have to see what happens. Now, the one real exception in this area that they talk about is garden leave provisions. And those are going to be permissible according to the FTC. Now, there's two different types of garden leave provisions, depending on what state you're in. The term is used differently. Here in Massachusetts, where I live, it's actually a post-employment period where an employee is paid to sit on the beach, tend their garden, sit on the bench, whatever you want to call it. But it's post-employment. They no longer work for the company. They're no longer receiving benefits. They're receiving some sort of compensation to sit out during the restricted non-compete period. That would be prohibited under the rule. What would be permitted is what effectively is a paid notice period, which other states use garden leave to describe. So what is that? You tell an employee they have to provide 60, 90, whatever it is, days advance notice. They're going to remain employed. They're going to be paid. They're going to receive benefits, but the company does not have to give them access to their systems, does not have to have them do any work. The employee can stay at home, but they're still employed. They still have a duty of loyalty. The FTC says that's okay because that's not post-employment. It's pre-termination or pre-resignation, pre-last day. And therefore it doesn't apply. The rule would not apply to it, and that's permissible. Don't know why they drew that line, because it's effectively the same as a post-employment garden leave, but so be it. Certain industries would not be affected whatsoever by this rule. That includes nonprofits, certain banks, certain common carriers. The real big area where we at EBG are seeing this as an issue is in healthcare, in particular with hospital systems. Some number, half, I don't know, Stuart will correct me if I'm wrong, of hospital systems are nonprofits, the rest are for-profit. because the FTC acknowledges that it does not have authority over nonprofits, it's going to create this weird dynamic where nonprofit hospitals can use non-competes, for-profit hospitals cannot. They're often competing in the very same markets. The American Hospital Association actually submitted some very thoughtful and well-done comments during the comment period, if you can find those online, that discuss this issue. But it's an issue that we're getting a lot of questions about. And in addition, oftentimes they'll have collaboration agreements, or the nonprofit hospitals, or they'll have subsidiaries that are for profit. And there's all sorts of those questions that we're getting. But the bottom line is that the FTC just simply doesn't have authority over nonprofits and other types.
On the other hand, state legislatures do, and some are attempting to fill the gap. There's a good deal of legislative activity that's going on among the states that could affect all of this. Likely to create conflicts because the laws won't be congruent with one another, even if they're passed. They'll be different in different states. We have many healthcare businesses, hospital chains, for example, that will be facing inconsistent policies. It will only get worse before it gets better.
That's right. And we've already seen, there's states, Massachusetts being another, an example, again, because I live here, where physicians, nurses cannot be subject to non-competes. Several other states have it, but they're all over the place. In terms of healthcare employees, typically apply to practitioners, sometimes veterinarians. I'll give a shameless plug to our 50-state non-compete survey, where we just added a 50-state healthcare supplement to it that talks about all of the exceptions in that industry. Now, the interesting thing about this is that the FTC acknowledges it doesn't have authority over nonprofits, but it essentially says, but we're not going to take your word for it that you're a nonprofit. In fact, we're not going to take the IRS's word for it that you're a nonprofit. We're going to do our own analysis as to whether you're a nonprofit. And if we determine that you're not really a nonprofit, or you shouldn't be, then we're going to claim that we can regulate you, and you would no longer be allowed to use non-compete agreements. The final kind of exception to the rule is that good faith but failed attempts to comply are not unfair business practices, meaning they don't violate Section 5 of the FTC Act. It doesn't mean a good faith but failed attempt to comply means that it will be an enforceable agreement. It will still be unenforceable, but you won't be subject to an action by the FTC. Again, this isn't so much a concession to businesses as I understand it, is attempting to avoid certain First Amendment arguments. Next slide, Glenn. So why is the FTC taking this action? Great question. We've got a slide here. These are actually this language comes from the proposed rule, but they have the same rationale now for why they're taking this action. They claim that non-compete clauses systemically drive down wages, even for workers who aren't bound by them. They say they're often imposed on low-wage workers, which just isn't true. They say non-competes reduce entrepreneurship and startup formation, also not true. And then non-competes lead to higher prices for consumers by reducing competition, which is a bit illogical when you compare that to their prior statement that this is going to raise compensation by hundreds of billions of dollars a year, and for whatever reason, they don't think companies will pass that along to their consumers. But Stuart's going to talk about the legal arguments. This really falls into why they're arbitrary and capricious, because, and we'll talk about it more, but these rationale that they have are just not based in credible studies, and they're cherry-picked studies and whatnot. Stuart and I, as you can see, wrote an article for Law 360 about this. If you're interested, we'd be happy to send you a copy, or there's a link there in the slide deck that you'll get.
Yeah, I'm particularly focusing on the second of these things, this idea about allegedly that non-competes reduce entrepreneurship and startup formation. What the commission says is when someone like me, which I've done, points out that the targeting really affects the most innovative people in startup corporations and exists for a reason. The commission responds and says, well, why don't you just protect your intellectual property and make sure that there'll be no use of your confidential business information, and you can always do that. Well, we're already starting to see what many people think is going to be a flood of patent and trademark litigation in this area, which is not a public good. But it doesn't recognize what often is an issue here, which doesn't involve protectable intellectual property as much as it does strategies and approaches, the things that make these companies go, and are carried out not necessarily by the founders, but by the managerial generation that is brought in at early stages of corporate development. The founders aren't going anyplace. That's not what we're talking about here. We're talking about people who make these companies run, who are developing not just intellectual property, but the systems, the management, the strategies. None of those things are protectable. Again, the Lena Khan and the commissioners that associate with her have never been involved in business. They don't understand what it takes to start a business, to keep one going. And in fact, what I'm suggesting is that just the sort of new businesses, smaller businesses that Khan and her allies purport to protect are going to be injured by this.
That's right. Actually, so are many of the millions and millions of employees, because oftentimes they are given additional consideration for these, such as long-term incentives, stock options, equity grants, and the like. Now, while we're on this slide, I'll point out just an aside up top. You can see I should have updated this slide, but I didn't. They talk about how they're number one there, that by stopping this practice, the agency estimates that the new rule could increase wages by nearly $300 billion per year. What's interesting is that, and I think the actual number was like 280 billion, whatever. In the new rule, in the final rule, the number they're now throwing around is $450 billion over 10 years, or 400 to 480, I think it is, over 10 years, meaning it's 40 to 48 billion a year, not 300 billion a year. So they make no effort to explain this six-fold decrease, but it's just another example of why it's arbitrary and capricious. In our view. So next slide, please. So what's going on? What are the challenges? As we mentioned, there's already been 3 lawsuits filed. The first was filed the day the rule was issued by Ryan LLC. That was filed in the Northern District of Texas. They filed a motion for stay the effective date of the rule and for a preliminary injunction on May 1st. And the court just this week issued a briefing schedule, and committed to getting a ruling out on the injunction by July 3rd, 2024. So just before the 4th of July holiday. The other lawsuit that actually we thought was going to be the fastest moving, just because originally the briefing schedule was the quickest, with Chamber of Commerce and several other organizations filed an action in the Eastern District of Texas in Tyler, Texas. That was filed the day after the Ryan case. They also filed a motion to stay and for preliminary injunction. Originally, there was a pretty aggressive briefing schedule set, but ultimately that judge decided to stay that case pending outcome of the Ryan litigation, which was first filed. And just today, actually, the chamber moved to intervene in the Ryan case. So
yeah, the judge in the chamber case apparently didn't want to work on the case at all. He invited the chamber to do this, and as Erik just pointed out, the chamber did do it.
Yeah, so all the action will be in the Ryan case. That's what we're watching. Full disclosure, we're filing an amicus brief there on behalf of 7 national industry organizations on the arbitrary and capricious issue. So we'll be monitoring that closely. And then finally, the 25th, so 2 days after the rule was issued, ATS Tree Services filed an action in the Eastern District of Pennsylvania, and there's not been much action there. But these are the cases that are pending. Again, Ryan's the one that's going to likely lead to an injunction on or before July 3rd. And Stuart's going to now start talking about the different legal arguments that these folks are making, and likelihood of success and all that. And by the way, all of these plaintiffs in these cases, they brought out the big guns. They've got the Supreme Court practices at major law firms. So they're all, in each of these cases, in the Pacific Legal Foundation in the third case. So they're certainly taking this seriously, very well represented, and that's frankly why we expect that they'll get some good results. Stuart?
Yes, next slide, please. If you've got to be any place, the Fifth Circuit is a good place to be. I note that at the beginning. I mean, there is already some action going on in the Supreme Court that can affect the outcome of these cases, even though the subject matter is completely different. But as a stepping stone to ultimate Supreme Court review, being in the Fifth Circuit, which has not so much been pro-business as it has been anti-agency in a great number of cases, is a good thing with regard to these challenges. Non-delegation goes back to the post-depression or to the depression view of non-delegation. None of us is old enough to remember the case of Schechter Poultry, the so-called sick chicken case, which instituted the theory of non-delegation, which lasted for some years and then went into great decline, and indeed it disappeared, especially throughout the 1960s and later on. But we've had something of a rebirth of that. Classic non-delegation focuses on the idea of whether Congress has the authority under the Constitution to delegate a function to an agency or anything in the executive branch. But a successor doctrine that is somewhat like non-delegation is the so-called major questions doctrine. The major questions doctrine has figured in two major cases. It came to the real fore in West Virginia against EPA, which is an environmental case. And it also figured in the decision in a case called Biden against Nebraska, which is where the Supreme Court struck down the Biden administration's initial student loan forgiveness program. To determine whether something is a major question, an agency action the court analyzes agency action in three areas. First, does the agency claim the power to resolve a matter of great political significance? Well, with regard to what we're looking at today with non-competes, the FTC has made no bones about the effect of this.
Okay, Stuart, I'll just add to that, whether it's a political issue, the president, I forget if it was last year or this year, during the State of the Union, talked about non-competes being used at Burger King or some such thing.
That's exactly right. It's part of the Biden little man program. It ties into pro-union statements that Biden has made elsewhere, and so the administration itself and what should be an independent entity, the FTC, has defined this political significance. This is a matter of major importance, both to Chairman Khan and apparently to the president as well. Does the agency, the second factor is, does the agency seek to regulate a significant portion of the American economy? Well, again, the FTC has told us that that's just what they're doing. They've made that point. In fact, as Erik mentioned a little earlier on in this talk, the number keeps going up. It's well on its way to $500 billion, even in old Everett Dirksen terms, $1 billion here, $1 billion there. Pretty soon you're talking real money. We're talking real money. Does the agency intend to intrude on an area that is the particular domain of state law? Well, nothing could be clearer about that here. As we pointed out in the preface, non-competes in the states go back 200 years. They've existed widely. They're well entrenched, and while states are free to act in that area, and many are, it certainly is an area that inarguably has been essentially in the domain of the states. So if you answer yes to all three of these questions, this is like a TV commercial, it is clear under the major questions doctrine, as Justice Gorsuch pointed out, an agency must point to clear congressional authorization when it seeks to regulate this significant portion of the economy. The FTC bases its authority on Section 5 of the FTC Act, which empowers it to regulate unfair methods of competition. But this is a stretch beyond measure. I think one must conclude that if indeed, it's going to be argued for sure. I mean, it's already in the case that if the court ultimately in the Fifth Circuit, if we got an appellate decision here, applies the major question doctrine, that it meets those criteria, and it will meet with a favorable majority if the case gets to the Supreme Court. Now, I'll confess that in the wake of West Virginia against EPA, I've seen a lot of cases. I practice in the Supreme Court and I'm involved in a number of active cases there, and I read a lot of briefs. And I will tell you that I've seen a lot of people alleging major questions, and they may be major to them, but it's not what the court has been talking about. The court doesn't jump on major questions analysis with alacrity. It does it in cases where the economics and political effect are clear. They are here, but indeed this program, this regulation rule it is to essentially repeal non-competes, it doesn't pass lesser tests than major question analysis. Indeed, in a number of recent cases in the Supreme Court, in other areas like dealing with COVID or with other regulations of the Department of Health and Human Services, the court has declined to award agencies discretion to interpret their statutes where there aren't clear congressional grants of authority, without even mentioning traditional means of looking at these cases, including now major questions doctrine, but even Chevron deference, and I'll come to that in just a minute or two. So we've seen a number of recent cases where, without mention of these restrictive views of congressional authority and agency action, the court has held that that Congress hasn't spoken clearly enough. And so, for example, the COVID regulation that applied against all industries with regard to the Department of Labor, OSHA, was struck down without any mention of any of these deference issues, without any mention of major questions or other delegations. So this is another way that the commission could lose. Should the agency get deference under Chevron against Natural Resources Defense Council, the famous statute or the famous case that has been the leading administrative law case over the last decades with regard to reviewing agency action and its interpretation of ambiguous statutes? Is Section 5 ambiguous? I don't see that it's ambiguous in the sense that one can imply the authority that the agency, the FTC, is exercising here. But the fact of the matter is that the court is assigning less and less deference to agency discretion. How do we know this? Well, a couple of terms ago, the court, in an opinion by one of the more liberal justices, Justice Kagan, narrowed the scope of agency discretion to interpret its rules in a case called Kaiser against Wilkie. And now the Supreme Court has a case that's under consideration called Loper, in which it's considering the breadth of Chevron deference, and one would expect not a repeal of it, but a substantial narrowing of it, so that legal questions are going to be within the domain of the court, where the sort of factual questions that a court has no competency to decide will be left to agency discretion. This is not a case like that. This is a case that involves a legal issue, and it requires no special expertise. In fact, as we've suggested, the FTC lacks expertise when it comes to analyzing the economic and business effect of this. So that's another way, if you will, just applying traditional modes of analyzing agency discretion that the FTC could lose in this case, and classic under the Administrative Procedure Act. Erik suggested earlier, and I'm going to pass the ball to him in a second, to talk about a little bit more about this. Is the agency action here arbitrary, capricious, or otherwise not in accordance with the law. I've dealt with the last part of that. They're not otherwise in accordance with law. But this is arbitrary and capricious as a matter of fact, as the dissenters have pointed out in the past, and other commentators have, including Erik and I. This doesn't make a whole lot of economic sense. That the commission majority's theory doesn't hold up in looking at the real world. So these are different levels, if you will, many different levels. Again, one can look beyond that to Fifth Amendment taking actions as well. You now see a whole list of at least 4 ways of attacking this, and at least with regard to 2, 3, and 4 on that list on the left of the chart, I think that the agency, that the FTC, is extremely vulnerable and likely to lose. And the challenges being mounted by very capable counsel, I think, are going to bring that to the fore. The Fifth Circuit is a jurisdiction that is amenable to these kinds of challenges, and this is something that is not unlikely to end up in the Supreme Court, especially if the Pennsylvania case somehow moves forward in a different direction and we get a split out of this. I don't think we will. I think the commission is going to lose. Erik, say a little bit more about arbitrariness and capriciousness here.
Sure. Thanks, Stuart. So as I mentioned, we're working on an amicus brief that we're going to file probably next week in the Ryan case. So we've been digging in quite a bit to the 570-page supplemental information, particularly our associate Carolyn Bouchick has done a fantastic job with that. But when you really dig in, you realize just how weak the case is for the arguments that, or excuse me, for the rationale that the commission has put forward for why this rule is necessary. First of all, as Stuart mentioned, the FTC doesn't have experience with non-compete agreements. They claim to, but it's kind of a comical claim, if you ask me, because they announced the proposed rule last January 2023, January 6th. On January 5th, they announced that they had just settled 2 enforcement actions. And in their press release announcing those, they said these were the first 2 enforcement actions that ever, dealt with non-compete agreements and companies using non-compete agreements inappropriately. Now, there were 2 reasons we thought why they were announcing these in this way, one before the other. Enforcement actions first. Number one, we thought it was probably for the interim effect of having employers speak out against the rule. The FTC's, flexing its enforcement powers, muscles, and essentially saying, if you're going to challenge us on this, you might be on the wrong end of an enforcement action. But even more so, we've seen that they're using this now to claim that they've got some sort of expertise in this area. When you really dig in, you find out that that's not only is that not true, but the arguments they're making are serious stretches.
Erik, it reminds me of the old joke about economists like these who see something working in practice and question whether it works in theory. I mean, that's really what we're looking at here. I mean, there is an impracticality about what it is that the commission majority is looking at here. That's been pointed out to them by the commissioners that have left and by the 2 new ones that have replaced them. But and I think that the Court of Appeals and irrespective of what happens in the district court, I think that the Court of Appeals and ultimately the Supreme Court will see it that way too.
That's right. And look, I'm not here to say, Stuart and I are not here to say that there's conclusive evidence to support that non-compete agreements are majorly beneficial for employees, for the economy, et cetera. We're just saying that it's a very unsettled area, as former Commissioner Wilson said in her dissenting opinion. The studies go in all different directions, and the FTC has frankly just cherry-picked not only the studies that it wants to rely upon, but the portions of the studies that it wants to rely upon. So an example of that is there's this seminal study from several professors I won't name, one of whom's a friend, and they came to and the FTC uses that study basically to set up how non-competes are used. They're used with low-wage workers. They're used in all sectors of the economy, all that. That all comes from this one study. What they don't take from that study, however, is the finding that when, and it's correlational, admittedly, and we'll talk about that in a minute, that when employees are given advance notice of non-competes, they typically are paid better, have better training, and are more satisfied with their jobs than folks who don't have non-competes.
And these things are matters of contract that they have consideration. And we're not here to say, for example, that the issues that pertain to the kind of employees that I was talking about earlier, those with management knowledge that can run businesses, that can innovate, should be treated the same way as somebody who is a food services person at a fast food restaurant. The problem here is that the FTC has acted arbitrarily and capriciously by promulgating a rule that affects all employees across the board, which really doesn't make a whole lot of sense. I mean, if we were talking about a given category of employees, like fast food workers, we might have something different to say than we would about a nascent captain of industry who has great management skills, can run a business, and can innovate, and whose services are core to the well-being of even startup corporations.
Well, that's right. And again, I like to say they're using a sledgehammer to kill a fly here, because they claim low-wage workers are adversely affected by these. Fine. The states are all dealing with that, or many of them are dealing with that by setting compensation thresholds. If the FTC had the authority to do this, which they don't for all the reasons Stuart outlined, they could have narrowly tailored a rule that set some sort of compensation threshold and said you can't use non-competes with folks below that. They didn't. They claim that that employers coerce employees to sign these things, and by that they mean they don't tell employees about it till their first day of work after they've left their last job. They've now need this new job, of course, and they're being told, well, if you want to start today, you need to sign this. Well, states are dealing with that too. They're requiring advance notice of non-competes. And this really gets to Justice Brandeis's idea of the laboratories of democracy, where every state is dealing with this in a different way. And by the way, the most employee-friendly states in the country over the last decade have considered banning non-competes. All of them started as proposed bans, just like the FTC here. But when they went through the dirty process of democracy and listening to all the stakeholders, not just some zealots, not just the employees, not just the employers, but everybody, invariably, with one exception, which is Minnesota, which is a very special state, but invariably all these other states ended up with a compromise that typically involved a compensation threshold, notice requirement, and other type of due process type obligations for employers when imposing non-competes or when asking employees to sign non-competes, which again, as Stuart mentioned, these are employees don't have to sign these. Sure, they might not get the job or be able to keep the job, but they don't have to sign them. And oftentimes they are given additional consideration and they're given additional access to information that they wouldn't have been able to have without the non-compete. They're being given access to customers that they wouldn't have otherwise had access to. But again, the FTC is cherry picking the studies and saying, well, this study says that they harm low-wage workers, but they ignore that there's other studies that say the exact opposite. And again, they're ignoring portions of studies that they don't like the one I mentioned earlier. And they say in all of the cases for what they don't like, the studies, they say, well, that's correlational. It's not causational. You know what? With the exception of one study that they point out is causational, which is really kind of a tertiary issue, all of the studies are correlational. There is no causational. This is labor economics, and they just haven't gotten there yet, or I don't know if they can. And one reason they can't is because of the inputs here. When we talk about studies, what we're really talking about here is surveys. And the surveys are asking employers and employees, do you use non-competes? Are you subject to a non-compete? What levels of employees do you use non-competes for? Do you enforce them? But what they're missing is that it doesn't matter how sophisticated you are, people often conflate non-competes with other type of restrictive covenants. So when they hear the word non-compete, they say, did I sign that? Oh yeah, I signed something. Well, that something might have been a non-disclosure agreement only, or a non-solicitation agreement, but not a non-compete. The FTC, I think, kind of backs into this unintentionally, and they say that, I think it was some of the small business commenters to the rule who were in opposition to it, she said, or they said, the majority said, they don't understand the difference necessarily between non-competes and other type of restricted covenants. Well, if that goes for small businesses, it of course goes for employees. And just based on my experience, I'm sure Stuart's seen this too, sophisticated clients use the term non-compete colloquially, and they don't really mean non-compete. They mean something else that this rule wouldn't cover. So again, the studies have bad inputs. They're cherry picking which ones they like. They're cherry picking which portions of those that they like. And they're taking all of this, wrapping it up in a nice bow and saying, well, let's change this major part of the economy based upon this kind of, again, cherry picked is the best word I can come up with. And to some degrees manipulated data to show that non-competes are very, very bad things and that they're harming the economy, they're harming employees, and they just completely give the back of the hand to any studies that, or ignore other studies that come out contrary to their policy goals. So unless you had more to say on the legal stuff, Stuart, we can move on to the practical considerations the last few minutes. So, we're getting a lot of questions right now from our clients. What should I do? A lot of them, what they see is what they read on the cover of the newspaper, whether it's the New York Times, the Wall Street Journal, et cetera. And what the headlines all said is that FTC bans non-competes. And if you read the article, there's still talk about how this, typically the media articles, frankly, will talk about how great the rule is and how many people it's going to help. And there's been articles about the challenges to it, but they typically don't come down strongly saying that the rule is likely to be enjoined and never go into effect, which is our strong held view. So we get calls all the time and employers are saying, what do I need to do? Do I need to cancel or whatever, all my non-competes now? And our answer is no. Our advice is stay the course and focus on compliance with evolving state laws and trends. Again, state laws where all the action is until it's not.
Yeah, and something that I suggest is not only transparency. I mean, tell people what you're dealing with here. There's no reason not to, and explain that there's a benefit and pay for it. I mean, these become more defensible when there is consideration that we can point to in a litigation. That we believe that consenting adults are capable of consenting, and that contractual relations are very healthy at every level. And as I say, these become more defensible where there is special consideration that one can assign to this, along with periods of applicability, a number of things that are specific to the employee's responsibilities, the needs of the corporation at issue.
That's right. In every state, the more you can show consideration, the more you can show that the restrictions are reasonable in terms of the durational scope of the non-compete, whether it's 1 year or a couple of years, the geographic scope. The more you can show that, the more likely you are to enforce a non-compete in court. Non-competes are typically enforced in the first instance with injunctions under the court's equitable powers, where no matter what the law says, the court has the discretion to make fairness or equitable determinations and decide whether to enjoin an employee from going to work for a new employer, as the case may be, or something less. So there are all sorts of safeguards built in addition to the fact that, unlike, and Stuart will know this better than me, but, in law school, I recall learning about just a peppercorn of consideration is enough for most contracts. Well, for non-competes, you typically need something more than that. And in many states, it's not just continued employment, for example, is not enough. So you got to make sure you're complying with state law and all of the states require reasonableness, no matter what the state law is, whether it's got carve outs for compensation or notice or whatever. But as Stuart was talking about, we don't stop there with our clients. What we tell them is, look, this is a great opportunity to take a holistic review of your restricted covenant and trade secret strategy and practices, because this is on the front page of the paper and on the TV and on NPR and wherever else. Boards know about it, are thinking about it. C-suites are thinking about it. They're trying to figure out what to do if the rule goes through, but also it's just front of mind. And so we encourage our clients to take this holistic review, inventory your current restrictions. Are you using non-competes where you don't necessarily need them, where something lesser may protect your interests, like a non-solicit NDA? Are there areas where you may want to use more non-competes because you haven't kept up historically as your company grew? What about when it comes to enforcement? What are you doing? And what about onboarding and offboarding? These agreements are only worth the paper they're written on if employees don't understand their obligations, whether that's through trainings, whether that's through onboarding and offboarding, exit interviews, reminding them, and not only reminding them the what and the how, but the why. Why is it that we do this? It benefits the company, but it also benefits you as an employee and you potentially as a shareholder if you're given equity or stock options. And this is what the only purpose of a non-compete, the only proper purpose of a non-compete is to protect legitimate business interests, trade secrets, confidential information, and customer relationships. So we're encouraging clients to take this opportunity, and there may be some dollars, some budget that they can tap into because this is so front of mind at such high levels. So considering things like a trade secret audit, no matter what, whether you have non-competes or not, a non-compete is just one single way of protecting trade secrets and customer relationships. If that's all you have, you're not going to be protecting your trade secrets and customer relationships. You need to be, again, training employees, but also are your technical capabilities up to snuff? Under any trade secret case, you've got to show as an element of the claim that you're taking reasonable efforts or reasonable measures to protect your trade secrets. And there's no real test for that, but having non-competes is helpful. But so is password protection. So is the latest cyber protections. So is training. So is need to know access. So is labeling documents. You don't need to do all these things, and there's others you can certainly do. But a trade secret audit will help any company figure out where their weaknesses are, what they can strengthen, how to do things better. Because again, whether or not this rule ever goes through, you still need to protect your trade secrets, and non-competes aren't going to be enough. And more often than not, when you're litigating one of these cases, it's because the employee took something, either intentionally or otherwise. And so there's going to be a trade secret claim there as well.
Well, as I said earlier, Erik, we're already seeing an increase in patent and trademark litigation that's attributable to what we're talking about today. But again, as I noted earlier, that's only part of the picture, and that a company is not really protected if all it is protecting are patents, copyrights, and other things that are trade secrets. There are intangibles that are unprotectable, strategies, things that are gained by experience, managerial functions and abilities. And that's key when you're talking about building and maintaining and growing, especially a newer business, a startup. Again, I suggested that there's no reason not to be transparent about this stuff. Employees ought to know why they're valued. When you're imposing a non-compete, you're suggesting that an employee is worth something to you beyond just a body that shows up to work, and that there's countervailing benefit here. And the kind of consideration that can support a non-compete is not just monetary. Making available training programs, seminars, things that are external to the company that build company goodwill and give an employee experience and scope and the like of that. Those are all things that go into the picture, and they're all, as I say, a function of good management, of transparency. There's no reason to hide the ball here and spring this sort of thing. You're explaining to an individual whom you're hiring that they have value to you, and consequently, you're going to have value to them. It's a good business contract, and this is good business.
That's right. And the final thing I'll say is just, you get the question, well, what about California? They don't have non-competes and they seem to be doing just fine. A couple of things. Number one, if non-competes go away, there's certainly going to be more trade secret litigation, which is far more complex, far more costly, and is going to get the employee embroiled in litigation if they take something, no matter what. So you're not saving there, you're actually just making it more costly for them. Number two is the industries out there, software in particular is so fast moving that stuff changes. And often it's open source stuff. So you've got different considerations in the software industry, for instance, than in other industries that you might see on the East Coast or in other places. Finally, North Dakota and Oklahoma, and now Minnesota, also ban non-competes. And if non-competes were really the reason, the lack of non-competes were really the reason that Silicon Valley has done so well, as some suggest, again, it's very causation or correlational, not causational. You'd expect to see all sorts of innovation coming out of North Dakota and Oklahoma and outside of Silicon Valley and California. And all respect to those places, they're doing great things, but those aren't necessarily the hubs of innovation. And where there are hubs of innovation, especially these days, Utah's a big one, Texas, Tennessee, they all allow non-competes. So that can't be the issue. And again, we're not saying non-competes are the reason there's innovation. We're just countering the argument that the innovation in Silicon Valley is a result of the lack of non-competes. With that, Glenn, that's our last slide. I don't know if we're able to take questions, but I know we'd be happy to do that.
We don't have any questions immediately on the Q&A we have, but I do have a few. First of which is, so for senior exec, for existing non-competes for senior executives, those are allowed to continue, but new ones are not. Is that just another arbitrary difference in the rule, or is there what was FTC's rationale for that?
Great question. The way they describe it is they didn't want to kind of throw a wrench in stuff that's already existing, because oftentimes for senior executives, it's not necessarily part of an employment agreement. They can be part of severance agreements where they've already received the consideration. They can be part of long-term incentive plans where they've been given vesting equity grants and options. And the FTC was saying, we don't want to throw a wrench in that. But the flip side of that is, if these things are so horrible and so harmful, and you're willing to do that in the future, to ban them in the future, then why not ban them now? And it's really, in my view, it was an arbitrary line they drew, but that was their rationale.
So you laid out a bunch of different arguments that are going to be made in the litigation. What are the chances that, especially the district court, will go the arbitrary and capricious route and do the constitutional avoidance thing and not get into major question or non-delegation or others? And do you see that possibly happening at the appeals court level as well?
Well, I certainly see it as possible, but within that circuit, there is a tendency to jump up the ladder. I don't oppose that, as I described earlier, but it would not surprise me if the Court of Appeals, particularly. I mean, I can't measure the case in the district court, and I'm thinking that whatever the outcome is, that we're looking at a Fifth Circuit case. The court could provide narrower reasoning than going full major question. We've seen it in other areas, as I mentioned, with regard to COVID vaccine rules and some other reimbursement rules of the Department of Health and Human Services in the two Becerra cases. I always argue for conservative interpretation principles, a la Justice Brandeis's famous concurrence in Ashwander against Tennessee Valley Authority. Courts tend to go farther in this kind of case. I think that's all that can be said with certainty, except that we've offered 3 or 4 rationales, any one of which can be applied here to the detriment of the FTC.
And I would just add, from a practical perspective, getting into the arbitrary and capricious is a lot more work. Having been going through it the last 2 weeks and digging into exactly why the rule and going through the 570 pages when you can get to for instance, the major questions doctrine, which seems pretty self-evident, but I'm with Stuart that it depends. And again, this jurisdiction is very well equipped to handle these administrative challenges. And frankly, I think it's the Ryan case. I could have it backwards. They're challenging the constitutionality of Section 5 of the FTC Act.
Yeah. So I mean, that's unlikely to be reached. I mean, the court has been concerned with this kind of agency issue in the context of the power of the executive to fire members of these so-called independent agencies, but I doubt that it gets to it here. One not so independent variable, though, is the Loper case. That's going to be decided before these cases are resolved, and so we're going to know about a narrowing of Chevron deference, and it very well could be, if indeed I'm right, and the Supreme Court decides that in a restrictive way, that gets immediately applied to the analysis of the non-compete rule. So the Supreme Court will tell us about that before summer.
But one of the things that you didn't mention was that this rule basically preempts 40 plus states' laws. Does FTC have the authority to do that? And if so or not, how is that going to work? Are they going to take enforcement actions against states for passing laws that aren't consistent with the rule?
Well, I mean, that in and of itself is a problem. The retroactivity issue that Erik mentioned earlier on really complicates that kind of analysis. So you know, it's not the sort of thing that the FTC majority would like you to believe, where, you know, it's benign and it just comes in without it making any waves. It makes a lot of them.
And that goes to the third element of the major questions doctrine.
That's right.
Why it's an element, which has this been the province of state law, which these have been not only for over 200 years, but since before the FTC existed and before the FTC Act was passed. And they've never before used this power. Clearly, in the 1890s is when California, and the 1870s when California, Oklahoma, and North Dakota banned non-compete. So this wasn't an issue that's come up more recently. It's something that's been debated in state legislatures since the beginning of our nation. And you know, that's why I think you raise a great point. They're preempting 46 states and laws, and I suppose if they had the authority to do what they're doing, that might be fine. But all these other reasons that they don't, including major questions for that very reason.
Somebody on our have asked a question. Is there any legal reason not to insert state law compliant non-competes in deal documents as placeholders and brackets in the event the FTC rule is set aside prior to a deal closing?
Well, I suggested earlier that these things ought to be as contractual as possible, and one ought to build, as just a matter of good employment policy, one ought to build into it issues of transparency, consideration, and duration, and the like of that. So, I mean, for the reason you imply, and things that we've both said otherwise, I would answer that question yes. Erik, do you agree?
Oh, absolutely. Like I said, stay the course. I would continue including these. We'll know by July 3rd whether the rule's enjoined. If we're wrong, there will be plenty of time to either undo that, or you're going to have to send notices if anything, you know, for existing agreements or agreements that are entered into between now and then. So you're going to have to do that no matter what. So you may as well continue and on as though the rule is not in effect until it's in effect. Especially by the way, they mentioned deal documents, especially if it would fall within the sale of a business exception, if it's the sellers of the business, not the seller's employees, but the seller of the business. That type of non-compete is going to be permissible, and those can last 5, 7, even longer years.
I wanted to mention one other thing that I forgot to say, Glenn. In a lot of these cases involving agency challenges, the challenges are losing in the Supreme Court and elsewhere when they cannot clearly demonstrate standing. That is a zero problem in connection with this type of case that we're talking about today. These businesses are affected in a way that's redressable, and standing should never prove an issue in them. So these are cases where the merits are going to be determined.
No, absolutely, you're right. So one more quick question to finish up here. You had mentioned that one of the challenges, I think, in the PLF run case was the constitutionality of Section 5, and the FTC instituted a new enforcement policy in 2022, I think it was, for Section 5. This definitely seems like it was more along those lines of what they sort of signaled in that enforcement document. If they had gone forward with this under the 2018 one, then you have to show, what's the relevant market here? What's the size of the market? Is it a market that there's not enough competition in? Or is there any signals here that you can see that people should be looking at with regards to their unfairness jurisdiction that might come up in other cases or the rulemakings?
I mean, I would say this case is not getting front page news, or it's really not being challenged by all these major players necessarily because of non-competes. It's because of exactly what you just said. It's all of these organizations. The chamber, I'm sure, has constituencies who love non-competes, constituencies who hate non-competes, and all sorts in the middle. They're not taking a position on whether non-competes are good or bad. They're taking a position on whether the FTC has the authority to do this and whether it's arbitrary and capricious, because at some point, the people who don't like non-competes aren't going to like the next rule, or they're not going to like the rule after that. And because they broaden their authority so much in that memo, this is really the first real, maybe not the first, Stuart, correct me if I'm wrong, this is a real test case of that expanded authority.
Yeah, there are others that are coming that relate to cybersecurity and data privacy affecting healthcare in particular. This is, it's childish to call everything, activist and overreaching. You don't need these kinds of adjectives. You can look at the volume of activity that the Federal Trade Commission majority is pointing out. There is support for this kind of thing, especially when we're getting to things that affect technology on the far left and the far right. So this is something where, I mean, what Erik is pointing out, this waterfall of activity is already taking place. I mean, this is an FTC that believes that it has a role in managing the economy. Forget that nobody there has ever managed anything that is involved in the private economy, and that indeed the agency itself, particularly when it comes to privacy, cybersecurity, and the like of that, can't meet the standards that it's trying to set for everybody else. Put all that stuff aside. It is an agency that is looking to stretch its power at a time when the courts are looking to cabin the power of the fourth branch of government, and I think that's the legal environment that we're in. And in terms of this case, in litigating opposition, being within the Fifth Circuit and getting to this Supreme Court is beneficial at cabining the role of and reach of the Federal Trade Commission that affects not only non-competes, but affects cybersecurity, that affects a whole host of modern day issues that corporations are facing.
I want to thank you both for joining us today. I think we had an excellent conversation. As Dick Thornburg, who is the late Dick Thornburg, who was the chairman of our Legal Policy Advisory Board, Stuart knows this, he would often end the programs that he hosted at WLF by saying, "Stay tuned." And that definitely applies in this context. And I wouldn't be surprised if we're back here in another 3 or 4 months or so talking about the outcome of the district courts, or once it gets up to the Supreme Court. So there's definitely a lot more to be discussed in this area. But I'm glad we were able to have this initial conversation, and I hope everyone who tuned in found it worthwhile of your time. It's good, like I said, it's been recorded, so you can check it out or share it with somebody. And also, after you sign off, there'll be a brief survey that'll pop up in one of your browsers. And if you could do us a great favor and do that survey, I'd really appreciate it. Gentlemen, again, thank you very much for joining us today.
Thanks a lot, Glenn.